Okay, I wanted to do a quick overview, sort of the special education 101 that I'm beginning to do. Uh, this one covering parent notices for meetings. Okay, and then the second one is, what about how much documentation or preparation in advance of an IEP meeting should a parent get? Okay, and what does the law say about that? And I can tell you that the law purposely doesn't say much about it because the entire point is to go into an IEP meeting with a open mind and fully capable to discuss everything, review everything, consider everything. So there is even sort of I'm not going to say a rule of thumb, but sort of an attitude from the feds who interpret, the IDEA for the states and the local governments, as to cautionary about, providing or creating these drafts in advance of an IEP meeting. We're going to get into that. I'm going to get into parent notices first. But what I wanted to say about that is that I can see both sides of that. There's only so much time in a day, and so if an IEP team were to start from scratch and develop that IEP fresh, the child profile, the goals, all of those things, then you're talking about hours and hours and hours of work. So I also believe that it's good to create drafts, um, IEP drafts in advance. But what the feds really want parents to understand is that those are just drafts. Those things are intended to be changed, to be discussed thoroughly, so that you as a parent have that input. And so there's a lot of schools that sit there and say, well, you have 30 minutes and here's the draft, but we're not going to let you see the draft in advance of the meeting. And that kind of stuff, that's wrong. I mean, it's not in line with best practice. It's not in line with the spirit of the IDEA. Now, is there anything that says that they can't do it that way? No. I mean, it's frowned upon because what it does is it really, really, really does put the IEP team at a disadvantage of not being able to create a truly individualized program where consensus is reached, and consensus meaning that parental participation and that apparent approval that IEP is designed to provide a FAPE for their child. All right, let's talk about meeting notices right quick first. I think that's the one I have pulled up. All right, and I'm using an Alabama one as an example. Okay, but what I wanted to, and so your state meeting notice is going to look a little bit different, but it's all going to have the same information. And so I want you to look on the left-hand column, the purpose of the meeting. That's very ambiguous, guys. It's purposefully ambiguous as to what the meeting is about. I don't think it provides sufficient information. I believe that there's been many situations, many cases I've had through the years to where that has been a trigger of unnecessary confusion and gotcha moments to where the school will ambiguously put, let's say, the fifth one down, review and revise IEP. I mean, what the hell does that mean? And what part of the IEP are we reviewing and what part are we revising? Are we revising or are we reviewing? And so in that particular situation, it would behoove the parents in an email to contact the director or the LEA, whoever is in charge of the meeting, and say, what is it that we're reviewing and potentially revising? And if they don't answer you, then I've had situations where they won't respond to the parent and let them know. But in that case, guys, the entire point of these exercises isn't necessarily to get the answers. If you happen to be in one of those bad schools with bad leadership, then at that point, guys, this is more of an exercise for you to safeguard your child legally and establish a paper trail that will lend itself to credibility for you in that you asked those questions. And at that point, it puts the school system at risk in not honoring your full right to parent participation. So the left-hand columns in most of these state notices are very ambiguous. You have a right to ask for clarification as to what specifically within those categories will be discussed in reviews, so you can come to the meeting fully prepared to participate. Okay, The left or the right-hand column with regards to who is invited. The ones that absolutely need to be there is the LEA. Okay, that's the person in charge of the meeting. And by definition, it's somebody who has to be knowledgeable of the available resources within the geographic boundaries of your school system and has the ability to commit the resources of the district on behalf of your child. Those two things are the legal definition of what a LEA is, the person in charge of the meeting. Quite frankly, as a principal, meet the strict definition? No, not unless the special education director has given them permission to commit the district's resources. And many, many times the special education director hasn't given the principal the power to commit the resources on behalf of your child. And I don't make a big deal about principals acting in the capacity of LEA if I'm not asking for anything out of the ordinary. But if I am coming into the meeting and I'm going to be asking for, let's say, an independent evaluation, or I'm going to be asking for, let's say, an outside third-party contractor, or let's say, for the school system to pay for a private placement, those will require a commitment of resources from the district. And at that point, you need somebody there present in your meeting that does have the authority at the meeting to commit those resources. And by and large, it's not the principal. Okay? That sort of should tell you something with regards to the true pecking order when it comes to special education funding and special education authority. And so many times, so many of these due process cases and the reasons that the IEP team doesn't function like it should is because of principals, and the principals end up creating problems in these areas. But like I said, if I'm not asking for anything out of the ordinary, then I don't make a big deal about the principal acting as an LEA. Now, the other one is someone who can interpret the instructional implications of the evaluations. That's only if your child's been evaluated, then that would need to be somebody who has an expertise to be able to interpret the evaluations results. And it can be a shared duty, a general education teacher or a special ed teacher, as long as they have that expertise, the LEA too, so they can serve both functions. General education teacher must be in your meeting. Must be in your meeting. I don't care how severely impacted your child is. I don't care if your child's at a special school. There must be a general education teacher there, because the entire idea of specialized instruction is and also least restrictive environment is that your child has access to the general curriculum and to general education students to the maximum extent appropriate. And the general education teacher there has an expertise and has contributing knowledge. So many times, guys, I've been at these meetings and the general education teacher is sitting there like a bump on a log, not participating, not interested. And that needs to change, because that's one of the important functions within it's one of those mandatory members. They have to be there. But at the same time, it's one of these things to where it is a common issue to where you sit there and you do not see the general education teacher participating in the development of your child's IEP and strategies and ideas and accommodations and supplemental aids and services, those kind of things that the general education teacher, as could sit there and assist the IEP team in order to fulfill those duties for least restrictive environment and then access and participation in the general curriculum. The other mandatory is obviously the special education teacher, the parent, the student when they become of age. And when I say student when they become of age, when the rights transfer to them, they're going to start inviting your child though at, let's say, 14 during the transition. Some states are going to be different with those rules. Please understand that you're still the parent. I don't necessarily like the idea of having the student participate in the entire IEP when we're discussing deficits and where we're discussing potential negatives or problems. I like the idea of having the student come in and self-advocate, and at the beginning of the meeting, participate in explaining to the team their goals, what they would like to do in the future, how they would like their IEP, or how they want the teachers to view them, and where they would like assistance, and then release them to go back to class or wherever. But having them through the duration of the meetings, I don't necessarily find positive. Career tech, when that becomes necessary, and then also transition agencies like your state's vocational rehabilitative service arm that is supposed to be there starting at that transition age, so that your child can transition over, and same idea on the front end when it comes to preschool, and that transfer over from that 0 to 3 age range. And then when your child transitions at age 3 to public school IEP services, then there's that 6-month transfer. On the back end, that's a lot longer. It's 14 to 21 or 14 to 18, guys. So that's a longer transition of having an outside agency not connected with the public school involved in your child's IEP program. Make sure your child is referred to your vocational rehabilitative services when they hit 9th grade or 14 years old, because that's very important. In a lot of states, they don't have a very good functioning system. That's no excuse. Since I told you, now you're aware, you need to sit there and push for that for your child. You see those other 3, you're sitting there going, well, where is physical therapist? Where is speech language pathologist? Where is OT? Guys, those are related service providers, along with, let's say, a behavior analyst. They're not necessarily going to be listed because they're not mandated members, okay? They're related service providers. So that's where you need to make sure that when you check those boxes down there that are blank, you can write those in. Guys, this is a two-way form. They will send you a meeting notice, but at the same time, and they'll have some of these boxes pre-checked. This is a contributory form to where when you send it back, you fill it out as well. So if you would like to have the participation of, let's say, the occupational therapist, physical therapist, speech language pathologist, behavior analyst, those kind of individuals, then you check those boxes and you fill in who you would like. And what I would recommend is next to it, you write out that if this person cannot be present in person, then they must ask your permission not to be present. So many schools will get into this habit of not having the speech language pathologist, OT, PT, behavior analyst attend and participate in your child's development of their annual IEP meeting. And I think that is absolutely insane, depending on the needs of your child. Now, do they need to be at every meeting? No, they don't need to be at every meeting. But some of these meetings, they absolutely need to be there. Now, there's a rule that says that they can sit there and participate via paper. And that's how it usually is done, is that somebody is there reading off the recommendations of the OT or the speech language pathologist, because they can participate in writing unless you specifically request that they be there. And that's how you do it. You check the box, you write out speech language pathologist, and you put in-person attendance in parentheses. The rule is that if you invite these people, the only way that they cannot be there is to ask your permission not to be present. They're not going to tell you that, but that's what the law says. They need to ask your permission not to be there. Now, during the meeting, what I recommend is if you do have the occupational therapist there, speech language pathologist, PT, behavior analyst, ask to have their sections performed first, OT first, then physical therapy, those examples. And then after they're done discussing their segment, let them go back to what they were doing. Release them. They're not mandatory members. They don't have to be there for the duration of the entire meeting. So you can release them, and they were there to participate. It was focused, let's say 10, 15, 20 minutes, and then they can go back to serving kids. Okay? They're related service providers. The ones that cannot leave your meeting is the LEA, the general education teacher, and the special education teacher. Never at any point can any of those 3 leave your meeting until the very end. If any one of them is not there, your meeting's done. It should be done. They cannot leave your meeting early and still have it be considered an IEP meeting. Remember that. And that happens so often, guys. I've had so many cases as well to where they'll have these meetings and it will just be the special ed teacher, or maybe the special ed teacher and an LEA and no general education teacher. Guys, you've got to have all three of those positions present at least. Okay? So when you sit there and you look at this, you can fill out those blank spots, as I said, all right? Also, on the other side, if there's a purpose that you would like to discuss in a meeting, check one of those boxes and you write out what you would like to discuss. All right, so now you go through the bottom of the form where it has the signatures and the dates. Also, you're entitled to your special education rights at least once a year, okay? Whoever sent you the meeting notice will sign right there, provide a telephone number, and then parent, check one of the following boxes and return the form to whoever before this date. And look at these ambiguous boxes again. I will be able to meet with you. I cannot meet at this time, date and time indicated. Please contact me to arrange another time. And the other one, I will not be able to meet with you. I will contact you if I want more information. Now, if they put a date on there and that doesn't work for you, and guys, depending on your state, unless your state absolutely specifies that you have 10-day, they must give you a 10-day notice before a meeting. But most of the time it's really flexible. That's what the Federal Register, sort of makes these recommendations, that it's sort of up to state and local policy. They don't want to sit there and hamstring and say you have to provide this much notice. I mean, I think that it's sort of common sense that, you want to provide enough notice, and some of these schools don't. I mean, they'll hit you and they'll say, well, we want to meet, we want to meet tomorrow. And, it just doesn't work. If that's the case, guys, then you need to check the box. I cannot meet at this date and time indicated. Please contact me to arrange another time. But you see all of this space over here, all this empty space. Guys, get a pen. Write out that you're interested in meeting, that you have a time conflict, and that you would like them to reschedule, and to please provide you with 3 alternative dates and times to choose from. I have so many situations to where I have clients that are single mothers that are working, and the only people that don't get paid at these meetings, guys, are the parents. All right. And so it becomes a financial burden. So for so many of these parents to sit there and have these meetings done when it's convenient for the school, which is during the middle of the day. They hate to have them toward the end of the day. Do you know why they hate to have them toward the end of the day? Because most of the teachers have children and they have responsibilities, and then they don't get paid. Now, I hate the hypocrisy of this. I do. I hate it when schools don't take into consideration parental circumstances with regards to parental finances, time off, things of that nature. And instead of just asking the simple question, what is your work schedule? Because there's some parents that they work on a different kind of schedule. Let's say Walmart, where they have Wednesday and Thursday off, but the school only wants a schedule on Mondays instead of on a Wednesday, or asking the parent in advance, what would be good for you? What works with your schedule? That's just respect, guys. You just make up these dates and you just pop these parents, and it's always within that block of time that's convenient for the school and not for the parent. There are times within the law that you need to, if the parent can only participate at a given time. I'm not saying that you have to bend to it every time as a school district, but yes, there are going to be some instances to where if the parent can only meet with you at 4 o'clock, then gosh darn it, that's when you need to have the meeting. That isn't to say all the time, but let's say an annual IEP meeting, if that's the only time they can do it and it's once a year, then that does not put a big enough inconvenience on the school system as to not comply with that request from the parent in order to achieve full parental participation and reach consensus for the development of an IEP meeting. Okay, I don't ever recommend doing this last one. It appears combative. I will not be able to meet with you. I will contact you if I want more information. That's basically saying, I don't even know why that's there. So you'll be able to attend. You cannot, but you need. I don't like even the second one without further explanation of you filling out that information on the side. And the reason I don't like it is that I have way too many cases, guys, to where the schools later, let's say you get into a due process situation, and what ends up happening is that, let's just do this. What ends up happening is that the in this situation and this space over here. And what ends up happening is that the school will frame the parent in a negative light. And what they'll say is that, because it's ambiguous, I cannot meet with you. And they'll just frame it as though you are the biggest ogre known to humanity, and that you didn't care, you didn't want to. And so what they end up doing is they end up using these situations to where what they'll do down here is they'll hit the documented attempts to contact parents, date, meeting, notice, result of first attempt, second attempt. And then what ends up happening, let me scroll it down a little bit. And what they'll do is within the law, it says that they need to give you at least 2 invitations before, well, at least that's how the school will frame it to you, is that they made 2 attempts to try to get you to go. And some of this stuff, they'll be sneaky about it. We'll only send it to you via mail instead of, attached in an email that people check more often. I mean, it's crazy stuff. I have some schools that they'll send it a return receipt, to where you have to go to the post office to pick it up. Guys, you know how difficult it is in somebody's daily life to just sit there and go, oh yeah, I got a return receipt and believe it or not, there's also collection agencies that send stuff return receipt. And so there are people out there, guys, that, let's say, single parents that, they're ducking collection notices, and you start sending us stuff that way, then, there's a chance that some of the parents are not going to pick that up because they don't want to know what the return receipt is. It appears very combative as well. So I just don't recommend that unless you're in a certain type of situation. But there's nothing wrong with attaching it to an email and then also sending it through certified mail or whatever if you want to do it that way. But also do it the convenient way. Guys, it's not like emails doesn't track, when you send it. And you can also set it on there, the settings of when it was opened or if it was opened on the back end. And it serves that purpose legally when it comes to a hearing anyway. But so many times, or they'll use their child as some kind of pack yak and send these meeting notices home. And let's say it works 90% of the time. I actually had a due process, guys, that went all the way to the appellate court, federal appellate court. We won, but I can tell you one of the things that contributed to the entire problem, where there was a disconnect and a miscommunication between the parent and the school, is that they were sending these meeting notices home with the son. And the kid was, I think, 8 years old at the time, high functioning autism, very intelligent kid. And what we ended up finding out at hearing, is that he was taking the meeting notices out of his backpack and he was throwing them away because he rode the bus home, and he didn't know if he was going to get in trouble because the parents, to their own admission, were a bit hardcore with regards to discipline, and he didn't know whether or not one of these meetings was going to be discussing his behavior at school. And he thought that by throwing the meeting notices away, and so what ended up happening is they would send her notice one, and the school, instead of just calling her, emailing her, they just assumed that she was just ignoring them. Then they'd send second notice, same thing, he would throw it away. And then they would end up having these IEP meetings without her present. And then they would send her, and then she would sit there and go, why in the hell did you guys have a meeting without me? Now, according to them, they sent notices. Mom was like, I didn't get any damn notices. I don't know what you're talking about. So it created a series of distrust. And instead of them having just some communication as to, well, we sent it home in the backpack with your kid, there was just no discussion. It was just a back and forth of, I don't trust you and I don't trust you, which then resulted in the parent coming to me. And then, it was a big enough issue. It wasn't just about that. But what I'm saying is that was a big trigger, though. It's an avoidable situation. So in that situation, guys, what does the law say, though? What is the language in the actual law when it comes to these first and second attempts? Guys, it says that you can have a meeting without the parent if you are unable to convince the parent to participate. Convince the parent. Not whether you made attempts to invite them. Guys, people have busy lives. Don't assume that when you send a meeting notice home that the parent hasn't been working 2 shifts, because they're one paycheck away from being evicted. Don't assume, and especially if you're giving 1 or 2 days meeting notice. I mean, come on, guys. It's so myopic to sit there and think that the world operates, around whatever your schedule is, however you live your life at home. And so let's say you're a very organized person. Oh, I get meeting notices for my kid all the time. Well, you're a teacher. You're right. Your kid's right there in the same school. You know all these people, and you also are very familiar with the school function and how school policies go and how notes home go and things like that. So it's really not a big surprise. But for other parents that have other jobs and other responsibilities, and depending on how many days that you give them notice, and I have clients that say that one of my clients was a flight attendant. Dad was a long haul truck driver, and grandma, the kid stayed with the grandparents, which was still in the same school district, but at the grandparents' house, a couple blocks away. These meeting notices were going, first of all, they were going home with the kid, but grandma, that's not grandma's responsibility. But, mom's off flight attendant for, let's say, a 3-day stretch, and, dad's long haul trucking. Grandma's getting the meeting notices, don't really know what they are, and also, let's say, they're being sent home to the mailbox. There are so many situations that it doesn't mean that the parent is refusing to participate. But yet the schools, because of how these documents are worded, results of the first attempt. A first attempt doesn't mean squat, guys. That just might not mean that you were able to make them aware that they didn't know. And it's amazing what we can do with text messaging now and with emails. And a lot of people have even moved away from email unless they work in a position like I do where, you email all the time. But there's some people that they just prefer text as sort of the new email. And there is nothing wrong with communicating with a parent in order to get that information out if that is the preferred way to get immediate contact and response. There are going to be those parents that are refusing, that you just will not participate. And there are those bad parents out there, guys. They are out there. They just don't care. Don't bother me with it. I send my kid to give myself a 7-hour reprieve, not because they're interested in helping their child improve. But don't make that assumption about every parent. And this is where you sort of need to understand your parents, and you need to understand their schedules, and you need to understand what needs to be done in order to make sure that you're not violating their rights to full parental participation by following stupid, ambiguous wording like attempt. Attempt is not convince. Okay? A convince means that the parent is resisting wanting to meet, that the parent is refusing to meet. And there are instances like that. I've had parents that are like, oh, they're going to change my child's environment. They want to have my child have a more restrictive setting, and I don't want to go to that IEP meeting because if I go to the IEP meeting, they're just going to do it. So that's avoiding the problem, right? In that situation, I've had parents that have purposely refused to participate. And in that particular situation, yes, a school system, after at least 2 attempts to try to convince the parent to participate in the meeting, can go ahead and have the meeting because the school system is the one that has the responsibility to provide your child with a free, appropriate public education. You do not as a parent. What you have right to is full parental participation, to consent to evaluations, and then you have the power of the dispute resolution formats if what the school system has proposed or has done did not provide a FAPE. So you have very powerful rights as a parent, but you cannot impede a school's right to have a meeting, okay, when it comes to the delivery and the provision of a free, appropriate public education for your child. So in that particular situation, if you are trying to just duck and get out of having a meeting, then in that particular situation, it's perfectly fine for the school system to do one attempt to convince you, a second attempt to convince you to participate, and then end up having the meeting without you there. All right. So I wanted to go back up real quick and cover this part where it says I give consent. This is for the transition agencies, okay? That's when your child is of transition age, 14 or 9th grade. Anytime after that, that's the second aspect that would need to be filled out as well. But please keep in mind that any of this blank space, please provide that additional information. And if you cannot meet, if they gave you a rotten time to meet, then you need to write on there that you are interested in meeting, but you have a conflict at the proposed date, and that you would like them to propose at least 3 dates and times for you to choose from. There is nothing wrong with that. And if you sit there and say, if you want to add on here, these are my days off, you can add that as well. These are going to be my days off, and if you can choose within this block of time that I do have time. It's their responsibility to send you the meeting notice, okay? It is not, these things are just BS, ambiguous, vague documents, guys. They're there as an invitation that a meeting needs to happen. That's even if you requested the meeting. You still need to wait for them to send you this notice. There is nothing wrong with you using this document as it's intended, and fill out what you need to fill out, as I explained earlier in the video. And then also, if they end up popping you with a date and time that doesn't work for you, you need to write out what I have said in this spot. And then quite frankly, you also, before you send it back to them, you need to take either a camera image or you need to scan it and keep it in your child's file. Because I have had schools before that have gone in and thrown these documents away and just created a new one and just checked the box. Because how can you choose? How can you determine that it wasn't you? And then you've signed enough stuff over the year, guys, that they just sit there and I've unfortunately I've busted schools doing this. That, I mean, they'll just manufacture these documents and then stick an overlay of your prior signatures, on these things. It's just not that big of a deal. Hell, if you have PDF editor, I mean, I can sit there and modify and change whatever I want to in whatever documents. So that's why it's important in our modern technological age to fill these documents out using pen, and then taking an image of that so that you have it as a safeguard and a backup, because there are people out there that do really cruddy things, or they'll say, we didn't get it. Oh, I didn't see that. What are you talking about? These excuses go both ways. As much as parents use them, so do school people. Okay? Safeguard yourself. And if you safeguard yourself, it safeguards your relationship with your IEP team. This has gone over. So what I'm going to do is I'm going to make it a sort of a two-part. And the next segment is going to be discussing the IEP meeting itself and how much participation a parent should be entitled to in advance of the meeting, so that in sort of best practice, what is it that would make a parent the most prepared going into an IEP meeting? And that's going to be part 2 of this.